Thank you, Madam Speaker, and I'm sure there were some that were hoping I'd come in here and some that were hoping I'd miss this. Nevertheless, Madam Speaker, I'm going to be presenting an amendment. Colleagues, I rise today to bring forward an amendment to enshrine meaningful conscience protection in Canada's medical assistance in dying framework. As senators who took part in the committee study will know, this issue came up on almost every panel during our pre-study, and again in our second committee study last week. In fact, it was striking how often the issue was raised and how passionate the pleas have been since. There were certainly concerned physicians and associations when we studied Bill C-14, and I advocated on their behalf. But this time it was one of the most prominent themes of our study. I contend that there are two reasons for this. First, the question of how this law will be applied by the provinces is no longer hypothetical. We have seen the requirements put on physicians who do not wish to participate in the ending of a patient's life. In fact, as the Canadian Society of Palliative Care Physicians stated, expected physician participation in MAID in Canada far exceeds that of any other permissive jurisdiction in the world. And secondly, this bill expands access to assisted suicide to Canadians who are not approaching the end of their natural life. This understandably gives even more practitioners greater pause. For some physicians, taking part in or facilitating such a procedure would be a violation of their religious freedom. For some, a violation of their medical ethics and their sworn Hippocratic oath. For some Indigenous practitioners, providing or facilitating MAID would go against their cultural values and belief systems. For some practitioners, it would be a complete violation of their medical judgment to refer, for example, a patient with a disability for a life-ending procedure when it is in their professional opinion that there are treatment options available. During our pre-study, when I asked Minister Lametti about the need for conscience protection in this law, he referenced the clause in C-14 and stated that safeguard is still there. However, we know now clearly that this clause provides no protection for healthcare professionals. It is true that no doctor in Canada is required to physically administer the lethal substance to a patient. However, in some parts of our country, practitioners are forced to provide an effective referral which will ultimately result in the death of their patient. The major understanding that seems to remain among legislators and regulators is what a referral means in medicine. The Canadian Medical Association explained the problem with forced referrals clearly when we were studying Bill C-14. They stated that an effective referral is essentially the endorsement of a procedure, which they acknowledged is morally problematic for many practitioners. One witness who testified on the last day of our pre-study, Dr. Coelho, said that she had been following the hearings and noted this deep misunderstanding from some senators of the meaning of a referral. She said physicians make referrals to a specialist, for example, when a treatment is outside of their expertise, noting, quote, "We don't make referrals for things we don't think are good for our patients." There is an ethical implication in a referral. It is not just a piece of paper and signing off to someone else. The government in Bill C-14 acknowledged that conscience protection was needed. However, the bill included a clause that was unenforceable, which explains why we have varying policies and varying degrees of forced participation across the country. Most provinces presently do not require effective referrals and have worked out reasonable access for patients without coercing physicians to participate in the process. Every practitioner advocating for meaningful conscience protection is more than happy to provide a website, a phone number, or provide information on any other self-access mechanism to a patient. In Alberta, for example, patients have access to the MAID Care Coordination Team without needing a referral from a physician. In Manitoba, there is a very clear standard of practice explaining that the grounds of conscience-based objection member can provide timely access to a resource that will supply accurate information about a medical treatment or a procedure. British Columbia's physicians are offered similar protection, and yet this is crucial, colleagues. The provincial colleges have confirmed that in provinces where the doctor has the right to opt out and self-access mechanisms are in place for patients, they have experienced no barrier to access, none whatsoever. In British Columbia, however, there is no institutional protection, which explains why Delta Hospice, a palliative care center, has been forced to shut down. The hospice chose to opt out of MAID as they believed it is a violation to the fundamental principle of palliative care, namely to not hasten death. The same lack of institutional protection exists in Ontario, PEI, and Quebec. With respect to forced referrals, Nova Scotia mandates effective transfers of care. However, physicians have assured us this has proven to be a referral by another name, as the transfer of care must be a willing MAID provider and has to be initiated by the objecting physician. Ontario physicians are required to provide effective referrals for their patients, even though telehealth can be used as a self-access mechanism for MAID. The infrastructure is there, and yet objecting physicians are being forced to leave the profession or the province. Physicians in this chamber will be familiar with the concept of MRP, or most responsible physician. When a patient is referred for surgery, for example, the surgeon becomes the most responsible physician for that patient during the procedure and would be liable if something unethical ensued. However, Ontario's hospital policies are making conscientious objectors who are forced to refer remain the most responsible physician for that patient, rather than the MAID provider themselves, even if that is in direct contradiction of the objector's ethics. This is wrong, colleagues. Many have asserted that this should be left up to the provinces to regulate. However, what has resulted since C-14 enactment is a patchwork of degrees of forced participation and lack of clarity. The Ontario Medical Association's letter to the Senate recently was quite remarkable, a quite remarkable indication of the need for clarity in federal legislation. When a provincial medical association asks Parliament to include explicit conscience protections for their physicians directly in our legislation, that is a pretty good indication that the system is not working. Yesterday, many of us received a letter from over 40 rabbis expressing grave concerns with the policies of the College of Physicians and Surgeons in Ontario. The letter states, the impending enactment of Bill C-7, along with the College's policy on requiring participation or facilitation of MAID, poses grave religious and moral issues to members of the Jewish faith. The letter continues, as it now stands, Bill C-7 would mean observant Jews who are healthcare workers will either no longer be welcome in the medical field or will be forced to abandon their deeply held beliefs. The rabbis conclude by pleading with the Senate for conscience rights, protecting physicians from direct or indirect participation of MAID. In provinces that currently have fulsome conscience protection, many physicians find it unsettling when the policies can and have changed at the whim of the provincial colleges. Physicians have no certainty as to the level of conscience protection they will be entitled to or for how long. And we know that Indigenous groups and leaders are gravely concerned about their lack of conscience protection, particularly as the assisted suicide regime is radically expanded. All of us received a letter from the Indigenous leaders across the country stating, Given our history with the negative consequences of colonialism and the involuntary imposition of cultural values and ideas, we believe that people should not be compelled to provide or facilitate in the provision of MAID. They continue, regardless of one's opinion of MAID, the right to self-determination and to act on one's conscience is recognized as a fundamental freedom in all peoples. Colleagues, all of these appeals are a clear indictment of the lack of protection under Bill C-14. Psychiatrist Sephora Tang, in a powerful presentation, told us, if the status quo remains, the state is essentially permitted to compel an unwilling practitioner to engage in an action they believe to be harmful to another person and effectively sets up the conditions for inflicting moral injury upon healthcare professionals. Honorable Senators, it has been said that the criminal code is a blunt instrument. However, in the context of this legislation, it is our only tool to implement policy with any enforceability. The amendment will criminalize any individual or institution who compels another individual or institution against their will to provide or facilitate in providing medical assistance in dying. The second clause clarifies that the obligation to provide the information is not included in the term facilitate. This is to ensure that physicians will continue to be required to provide information on self-access mechanisms, which have been and continue to be effective across Canada. Let's be clear, colleagues, the effect of this will be to force provincial colleges to establish policies that are in line with Parliament's intent. Colleagues, if the last few days have demonstrated anything, it is that there is no clear consensus on how to legislate compassion, how to ensure that adequate safeguards are in place, or how to achieve the goal of patient autonomy. An even higher degree of professional disagreement and moral variances exist within the medical profession. Given that we know there is no certainty or uniformity among the provinces, no barrier to access in provinces in which practitioners are fully protected, and given the pleas we are receiving to intervene from forced participants, Indigenous leaders, professional association, and even a provincial medical association, it is incumbent upon us to make this protection clear, certain, and consistent. In a pluralistic society, I submit that this is the only responsible and balanced approach. We owe it to our healthcare professionals. Honourable Senators, I move that Bill C-7 is not now read a third time, but that it be amended on page 7 by adding the following after line 30. 1.1, the Act is amended by adding the following after section 241.2. 242.21 subsection 1. Every person who compels another person to provide or facilitate the provision of medical assistance in dying is guilty of an offense punishable on summary conviction. Subsection 2. For the purposes of subsection 1, a person who provides information on medical assistance in dying to a person who requests it does not facilitate the provision of medical assistance in dying. Thank you, colleagues.